access to the ballot box, especially for African American and minority voters. The 5-4 Citizens United decision that overturned the law of the land and lots of Supreme Court precedent in order to empower corporations to spend unlimited sums of money in support of candidates for public office, corroding the fabric of our democracy. Decisions that limit a woman's access to safe and affordable birth control and reaffirm the legal fiction that for-profit corporations should have the same rights as real people. Decisions that upheld the Affordable Care Act, and a decision that with a single vote gave every American the right to marry the person they love. Mr. President, the decision of a single Supreme Court justice can indeed change the trajectory of our judiciary and of our society for generations. Now, my Republican colleagues rightly note that this weighty decision begins with the president. They have routinely said it is the president's right to choose his judicial nominees. And that's true. I have one question for them. Where were they last year when President Obama nominated Merrick Garland to the Supreme Court of the United States? They were AWOL. Shortly after Justice Scalia passed away and before President Obama even named his nominee, the Senate Republican leader announced that he would leave the seat open. And he did, for an unprecedented 293 days. For 293 days, Mr. President, one of the most qualified and mainstream nominees in our history languished without even a hearing. Many senators refused even to meet with him. For 293 days, Democrats in this chamber and people from all over the country called upon this Senate to do its job and consider the nomination of Judge Merrick Garland. The response? Nothing. A total abdication of this Senate's constitutional responsibility of advice and consent. But unfortunately, this chamber's failure to live up to its responsibility to consider the Garland nomination is just one piece of a larger assault on the independence of our judiciary. President Trump has made it clear that he sees our nation's judges not as a separate and co-equal branch, but an unwelcome challenge to his power. He's called the courts broken and political. When he faced trial for scamming thousands of students at Trump University, he charged that the federal judge overseeing that case could not be impartial. Why? Because he said he was Hispanic. A charge that was, in the words of the Speaker of the House, Paul Ryan, the textbook definition of racism. When the Trump administration first tried to impose its Muslim ban, only to be blocked by a federal court, did President Trump display respect for the rule of law? No, he fired his acting Attorney General, Sally Yates, and accused her of having, quote, betrayed the Department of Justice. He went on to say that if any future harm occurs, it's the fault of the courts, and called them obstructionists for not bending to his will. They're not supposed to bend to the will of the executive. President Trump's disdain for the courts makes it all the more important that the open seat on the Supreme Court be filled by somebody who's seen as an impartial administrator of justice, someone who does not have a set political ideology. Unfortunately, Mr. President, Neil Gorsuch does not meet that important test. His record and his testimony shows that he applies a very cramped reading of the law and consistently, time and again, sides with powerful corporate interests against the rights of workers, consumers, and individuals. When he had an opportunity during the hearings to explain that bias, he chose instead to evade the questions and answer with platitudes, not substance. While he's undoubtedly a skilled lawyer, his record reveals that he is outside of the judicial mainstream. His decisions have closed the doors of justice to working people, to people with disabilities, and to individuals seeking to protect their rights. In one opinion, Judge Gorsuch was the only judge who thought that Trans Am Trucking Company was right when they fired a driver whose only offense was finding safety when the heat in his truck broke down in sub-zero temperatures, and he began to show signs of hypothermia. The driver said he could not feel his lower body. His fingers were becoming numb, and he experienced slurred speech while waiting for hours for help from his company. Judge Gorsuch was the only judge who thought that federal regulations protected the trucking company and not the truck driver trying to avoid freezing to death. It makes me doubt that Judge Gorsuch considers the real-world consequences of his ruling. Judge Gorsuch also sided against working people and defended powerful corporations in his opinion in Hobby Lobby. There, he came down on the side of corporate power against the rights of workers. He argued that not only do corporations have rights to religious liberty, but those rights can supersede, can trump the rights of working Americans. He was the architect of an opinion that severely limited a woman's access to basic reproductive health care. In yet another ruling, Judge Gorsuch prevented an autistic child, Mr. President, from getting a proper public school education. His opinion on the Individuals with Disabilities Education Act severely limited the options for parents of children with disabilities and the quality of public school education in their reach. His reasoning in that case was overturned by the Supreme Court literally as he was testifying in the Senate Judiciary Committee. Not merely was his decision overturned, it was overturned unanimously, 8-0. According to the justices that Judge Gorsuch hopes to serve with, his standard would have cut children with disabilities out of high-quality education. As the Supreme Court said in that case, quote, "For children with disabilities, receiving instruction that aims so low would be tantamount to sitting idly, awaiting the time when they were old enough to drop out." That's what the court said. Fortunately for children with disabilities and their families, and for the sake of justice, they did not adopt the Gorsuch reasoning. Finally, Judge Gorsuch has spent his career arguing against the so-called Chevron standard. In essence, this means that when it comes to federal rules designed to protect the public health and safety, he believes that the opinions of judges like himself should outweigh the opinions of experts in these subjects in our civil service. This view was rejected by none other than Judge Scalia. It is much more in line with the thinking of Steve Bannon, a man whose stated goal is to deconstruct the federal rules that protect the health and safety of the American people. Again, Mr. President, Judge Gorsuch is not in the mainstream. And let's make no mistake, he was never intended to be a mainstream nominee. Candidate Trump established several litmus tests. He said he wanted a nominee who was opposed to a woman's right to reproductive choice and someone who would have the support of the NRA. He then subcontracted out the nomination process to right-wing conservative groups like the Heritage Foundation and the Federalist Society. He asked them to compile a list of nominees who they liked. Neil Gorsuch was on that list. So it should be no surprise that an analysis that appeared in the New York Times concluded that Neil Gorsuch would be the second most conservative member of the current Supreme Court. And an analysis in the Washington Post concluded he would be the most right-wing member of the court. And once President Trump selected Neil Gorsuch, the right-wing money machine went into action. Since that moment, money has flooded our airwaves, more than $10 million spent in support of this nomination. Never before has our country witnessed a multi-million-dollar campaign for the Supreme Court. When pressed, Judge Gorsuch said he had no idea who or why anybody would spend that much money to make sure he sits on the highest court. I think we know why from looking at his record. They want someone who consistently rules in favor of large corporate special interests against the rest of us. Mr. President, there's a better way. Typically, the White House will consult with members of both parties, Republicans and Democrats, before settling on a nominee. This time, that courtesy was not extended to Democrats. If it had, we could be talking today about a bipartisan nominee, someone who would uphold equal justice under the law for every American. The rules do not need to change. The nominee needs to be changed. Mr. President, our nation's independent judiciary is under attack. Our president demonizes judges whenever he feels challenged, and now special interest groups have begun funding millions of dollars into a campaign, reducing our solemn constitutional duty to a set of slick campaign ads. That's why we need a new nominee, one who has the support of 60 members of this chamber. Mr. President, I will oppose this nomination and insist that this nominee be held to the 60-vote standard to show he can get a consensus of this body. I yield the floor.
Mr. President.
Senator from New York.
One of the most important constitutional duties we as senators have is to